time. We have 3 speakers with us today. They are all from the Office of the Lawyer's Professional Responsibility Board. We have Jennifer Bovitz, who is a Senior Assistant Director. We have Kathy Hansen, who's also a Senior Assistant Director, and Linda Nelson, who's a Paralegal Supervisor. Please help me welcome them.
Good afternoon. Thank you for coming. This is a great turnout. Obviously, this is a topic that is of interest and is an important topic for the bar. I did want to note that if you have questions, feel free, either if you're watching on the internet or if you're here in person, raise your hand or type in a question. We will take questions as they come. We'll also try to leave a couple of minutes at the end for questions, and we'll also be willing to stay after for several minutes if you want to talk to us in person. So we're going to start with the basics. Why do lawyers need a trust account, and who has to maintain one? Well, everyone hopefully should know a trust account is an interest-bearing bank account that contains funds entrusted to the lawyer either by the client or a third party. Rule 1.150 defines different types of accounts that can be used as a trust account. So you can have a trust account, and you can also have different types of accounts that can be used as a trust account. Most people use well, let me go back to what the purpose of a trust account is. Why do people have trust accounts? Anybody want to take that one? What is the purpose of a trust account? Does anyone know? What's the purpose? Right, so it's twofold. It's to safeguard client funds and third-party funds that are entrusted to you, and it's also to keep your personal funds, your business funds, separate from those client and third-party funds. Does anybody know what rule of professional conduct governs trust accounts? There is a specific rule. Does anyone know it off the top of their head? Yes. And is everyone familiar with Appendix 1? If you've never read Appendix 1, you should read that. That gets really specific in detail about records and books that lawyers are required to keep. So basically, the need for a trust account usually arises when a lawyer is paid a retainer or a flat fee for work to be done in the future. I want to draw a caveat here. We don't have time to get into fee agreements, but I would encourage everyone to review Rule 1.15b1, which is a type of fee agreement that if a lawyer is completely compliant with all the provisions, a lawyer can charge an advance fee for specific legal services to be provided in the future and not put the funds in trust. But we're not focused on fee agreements today, we're focused on trust accounts. So who is required to have a trust account? Anybody who handles client funds. So really the only lawyers who aren't going to need a trust account are in-house counsel, government attorneys, law clerks, but really anybody engaged in the practice of law at some point in their career is probably going to need a trust account for some purpose or another. There are many professions like criminal defense attorneys who say, we do all of our fee agreements with this flat fee in compliance with Rule 1.5b1. I don't need a trust account, but there are times in litigation where you're going to have to pay expenses or costs on behalf of the client. You need a trust account for that often. So it's just generally as a ground rule, unless you're in government, public sector work, or in-house counsel, you need a trust account. Does everybody know about the certification requirements on your annual registration statement? Yeah, so when you pay your fees each year with lawyer registration, there's a section where you have to certify whether or not you handle client funds. And that actually ties into a subsection of Rule 1.15i. You have to certify whether you maintain a trust account and that you keep books and records in compliance with Rule 1.15h. It's important to note that that certification actually means something, because we've had lawyers who have made that certification on their lawyer registration statement. They've then become the subject of a discipline investigation. Our office looks at that. I will look to see if you've certified that you're keeping trust account books and records, and if you're not, lawyers have been charged with making a false statement on their lawyer registration statement. So, when you check that box, really give it some thought, because it is a certification, and you are held to the authenticity of your statements on your lawyer registration form. So we're going to start with the basics. What is an IOLTA account? An IOLTA account, that has a specific meaning. It stands for Interest on Lawyers Trust Account. An IOLTA account is a pooled, interest-bearing, insured depository account for holding client funds or third-party funds that you've received in connection with the representation of a client. So we're not putting, your neighbor gives you $300 that he just wants you to hold on to. He's not your client. Those funds don't go into your IOLTA account. So these are funds received in connection with representation of a client. The most IOLTA accounts are going to be what's called a pooled IOLTA account, and that means that you're holding funds on behalf of multiple clients in one IOLTA account. And the cumulative interest on that account is calculated on the pooled balance of all of the client funds that are in the account. We frequently, on our advisory opinion service, get questions where a lawyer has gone to a financial institute and tried to open an IOLTA account, and they were told that they need a trust document to open a trust account. You don't need a trust document to do that.
From us.
At least not from us. Oftentimes, banks are saying that, and they don't really understand what it does. But if that circumstance ever arises, you can call us for an advisory opinion, and we can talk to the financial institute. So, what funds go into the IOLTA account? Again, it's those funds that are received from clients, third parties, not non-client funds, and not your own business funds or your own personal funds. What happens to interest on an IOLTA account? Again, when you're talking about an IOLTA account that is a pooled account, so pooled account of multiple client funds, that interest is going to be interest that is nominal or only being held for a short period of time, and that interest is paid by the financial institute over to the IOLTA program. And those the funds from lawyers' trust accounts go to fund various legal services programs. So pooled IOLTA accounts are multiple client accounts, and the funds that are in that account are generating interest, but it is interest that is nominal and held for a short period of time. In a couple of minutes, I'm going to talk about a different type of trust account when the interest is not nominal and needs to be paid to the client. Can a lawyer calculate and pay interest to individual clients? Sure. You could have a pooled interest-bearing trust account, and you could have multiple client funds in there, and you could be individually paying interest to your various clients instead of having the interest being paid to the IOLTA program. Again, that would be because the interest is substantial in amount and needs to be paid back to the client. That's a very difficult thing to do. In fact, in my 18 years at the office, have never seen a lawyer do that. And Linda, have you ever seen that? Mm-hmm. Right. So usually for the average lawyer, you just have your pooled IOLTA account and your interest payments are being paid over to the IOLTA program. Where can a lawyer set up an IOLTA account? This is another frequent question that we see on the advisory opinion hotline. We actually have a list of approved financial institutions on our website, and you can go to the trust account section at the OLPR website and click on this list. We only allow IOLTA accounts to be opened at a financial institute that has signed an agreement with our office, and the purpose of that agreement is twofold. One, it's to ensure that if the trust account goes negative, that they will report that fact to our office, and that triggers an overdraft investigation by our office, which we'll talk about later. And the second purpose of that agreement is to ensure that the financial institute is agreeing to pay a minimum level of interest on the IOLTA account. So you can't open a trust account at a non-approved financial institute. That's Rule 1.15J, and we have a list of those on our website. In addition, how can you name your IOLTA account? Well, your IOLTA account should clearly be designated as an IOLTA account. It should be, my last name is Hansen. It could be the Hansen Law Firm Trust Account. It could be the IOLTA Trust Account. It has to be clear. You have to be putting the public on notice. The reason why we want the word trust account and IOLTA account in there is we want to put the public on notice that this is a fiduciary account. Your creditors for your law firm should not be trying to attach funds that are in the trust account in collection purposes. So that just helps to ensure the fiduciary integrity of the account. Similarly, when you have a business account, you should label that as business or operating account so that the two are clearly separate. Just as a side note, we often see lawyers that get checks for their operating account and their trust account the same color. Just have those separate so that you know blue is operating, green is trust account, so you don't get them mixed up. So I want to go back to something that I talked about earlier, where I was talking about IOLTA accounts for pooled client funds, so multiple client funds being held in one trust account. You can also establish a client trust account for an individual. And you can have as many of those individual trust accounts as you want. You still have to do all of the record keeping for each individual account, which is why lawyers generally choose not to open up individual client trust accounts, because it's a lot of work with reconciliations and books and record keeping. But what is an individual trust account? Where can this kind of trust account be set up, and when is it appropriate to open an individual account over a pooled IOLTA account? So an individual client trust account is the same as a pooled IOLTA trust account. It's still an IOLTA account. The main difference is that you're going to be depositing funds belonging only to that client, and the interest generated from holding those funds is going to be paid back to the client, net any cost associated with maintaining the account, such as like the account fee that the bank charges to have the account. So basically the difference between the individual client trust account and the pooled IOLTA account is who is getting the interest. In the pooled IOLTA account with multiple client funds, the interest is paid to the IOLTA program. In the individual account, the interest is paid back to the client. So the rules offer guidance to lawyers when they're trying to determine whether they should be opening an individual account for a client or whether they should put that client's funds into their pooled IOLTA account. And Rule 1.15G and Rule 1.15F, talk about the, giving guidance, but it's pretty basic. If you're going to be holding funds for a long period of time, and the amount of funds that you're holding is going to generate substantial interest, meaning interest that isn't nominal, interest that is going to be more than the cost that it costs you as a lawyer to maintain that independent account with the bank, then those funds should be paid to, that interest should go to the client. A frequent example would be lawyers in dissolution matters, where you're holding homestead proceeds on behalf of the parties pending final judgment and decree. Oftentimes the homestead proceeds can be substantial enough, and you might be holding them for a long enough period of time that interest would be not be considered nominal and should be paid back to the client. That's usually the most frequent circumstance that I can think of, but so you really have to think about how much does it cost me with the financial institute, what are the account charges for maintaining and operating the account, how long am I going to be holding it, and is that going to eat up any interest that would be generated by that account? So the record keeping obligations for an individual trust account or a pooled IOLTA account are the same. You have to maintain records for each trust account that you have for a period of 6 years. And this obligation in particular is why you don't see lawyers having multiple individual client trust accounts, because then you're keeping records on all of those accounts for the 6-year period, and you have to engage in duplicate balancing and reconciliation procedures with those accounts. Any questions? So there are also additional considerations that can make individual client trust accounts more complicated, and there are some financial institutes will only allow, the complications are twofold. How can you open the account, whether in the law firm's name or the client's name, and then the tax ramifications of whose name the account was opened in. So some banks will let a lawyer go in and open the trust account in the client's name using the client's tax ID number, but with the lawyer as a signatory on the account. I will say that there are a number of banks who don't like to have a trust account, like trust account for Cassie Hansen, and then Cassie Hansen is the client and she's not the signatory on the account. Lawyer Joe Smith is the signatory. They like to see the signatory match up with the name on the trust account. So if the bank is not going to let you open the individual client trust account with the client's tax ID number and then the client's name, then your option is to open it as trust account for the name of the client using your law firm's tax ID number, but then you have to remember that you have to do 1099 tax forms for any interest that you pay out to the client.
Cassie, I just saw a question about that. 6 years from when?
From the
What
date
was the question?
yeah, from the date the account is opened.
No, the retention.
Yes.
Isn't it 6 years from the calendar year in which there was?
Yes. Go ahead.
Yeah, there was activity in the account.
So again, the individual client trust accounts can be complicated because banks only let you designate them in a certain manner. And if you have to deal with the tax ramifications of issuing a 1099 to your clients for paying out interest, that's another thought to consider when you're determining whether you want to hold those funds in a pooled or individual trust account. So whether you're moving or closing a trust account, the steps are the same. This is, if you have a pencil, you can write this information down. This is who you contact when you're moving or closing your trust account. You have to notify your bank to close the account, and then you have to fax the letter to the number that you see on the screen with the attention of the IOLTA program, with your name, your firm name, the account number, and the date it was closed. This information is also available on our website in the frequently asked questions section.
When you're closing a trust account, be sure to account for any accrued interest. So let's assume your bank pays interest into the account 1 month and then remits it to the IOLTA program the following month. And let's assume you're closing the account on October 31. So if you close that account on October 31 and don't retain in the account an amount sufficient to cover the interest that's going to be remitted in November, you're going to be hearing from us because it's going to generate an overdraft and we're going to make inquiry. So just remember to account for any accrued interest.
So now we're going to get into the section where we're actually going to talk specifically about record-keeping obligations, both records and books. Again, I'll refer you back to Rule 1.15 of the Minnesota Rules of Professional Conduct and Appendix 1, which set forth the technical requirements for maintaining trust account books and records. This section is all about documentation, and you have to keep those records. It doesn't do you any good if you're, and we'll get into that specifically, but I just want to make people aware, it doesn't count if you're keeping some and not keeping others. You have to keep all required records. And we'll talk about some of the frequent bookkeeping errors that we see, but not keeping certain required records is, a frequent cause of attorney discipline through our office. You are permitted to keep records electronically. A lot of times we do see lawyers who don't back them up. Linda, can you tell us what you recommend to people for how frequently they should back up electronically kept records?
Frequently?
Do you have a?
It depends in part on the volume of activity in the account. If you've got an account that's really, really active, maybe you're a collection lawyer or something like that, you're probably going to want to back that up more frequently than if you're just an occasional user of the trust account. But an account with substantial volume, I would say daily.
Yeah.
If you are delegating these books and records responsibilities to an accountant or bookkeeper, you need to make sure you're supervising these activities and making sure the records are being maintained in that capacity as well. So just because you've delegated the responsibilities to someone else doesn't take you off the hook, or you can assume that the records are being maintained appropriately. That's a really important key piece here, and we're going to talk about that a little bit in the discipline section as well.
Yeah, and if you're not keeping the records and you become the subject of an overdraft inquiry or a discipline investigation, you don't just get to be like, sorry, I wasn't keeping them. We'll make you go back and recreate them. And we've also had lawyers whose systems have crashed technical problems, and then they don't have those records because they didn't back them up. So if you are doing them electronically, you really backing up your records is a real thing. And then the site on the slide is In Re Writer. This is a seminal attorney discipline case, just reiterating how important a lawyer's obligation to independently maintain and verify that their non-lawyer assistants are maintaining those books and records. Failure to keep required books and records can result in various levels of discipline, which we'll talk about a little bit later in the program. So we'll start with records. Records are the documents that are created in the ordinary course of operating a bank account or handling other client property. Record keeping requirements are contained in Appendix 1, Roman numeral Section 1, subsection 6. So records as defined are bank statements, canceled checks, deposit slips, bank interest reports, service charge notices, and notices of interest payments on the IOLTA program. So records are basically routinely the records that the bank provides to you. Generally, bank records are considered to be the documents that the bank sends to you in the course of operating and overseeing your trust account. Again, these records have to be kept for 6 years. What if, some specific notes regarding records, what if your bank doesn't return original or copies of canceled checks with your bank statements? Are you required to order those or to make or retain copies of the checks drawn on the trust account? No. If the bank doesn't provide those to you, you are not required to make or retain copies of checks drawn on the trust account. If your bank does not return original deposit slips, however, you are required to create and retain duplicate deposit slips. That's usually using a book with carbon copies when you're doing your deposit slips. That carbon copy is your duplicate deposit slip. And the reason for that is because the lawyer needs to maintain a record of the clients on whose behalf the funds were deposited. So if your financial institute where you maintain your trust account doesn't provide canceled checks, that's not something that you need to independently make or retain copies of the checks. But if they're not providing you with original deposit slips, then you need to create and retain duplicate deposit slips.
Can you use the checks that you get as a backup for your deposit slips?
So the question is, can you use the checks that you get as duplicate? We're repeating the question because there are a significant amount of online viewers, so that we want to make sure they hear your question.
Oh, okay.
Can you use the checks that you receive as duplicates for your deposit slips?
Correct.
Go ahead and take that, Cassie.
I don't think
No.
so.
No, and we're going to talk later about how you're supposed to actually annotate your deposit slips, but no.
Can I ask a question about electronic deposits and other kinds of electronic payment forms? If I'm not making out physical deposit slip that goes directly to the account, to the trust account.
We're going to get to that in a section if you can just hold on. Okay, so what information do you need to have when you open a trust account? You need the name of the financial institute. You need to verify that it's an approved financial institute. You need the account number. You need the account name, the date of the account opening, a copy of the account application, and you should also maintain a record showing when each account was, or whether the account is pooled or whether it's an individual account, including the client's name if it's an individual account. And oops. Okay, so this will get to your question. How is a lawyer supposed to annotate deposit and withdrawal records? So each deposit slip has to clearly identify the client on behalf of whom the funds were deposited. One thing that we frequently see in our trust account audits is a deposit slip that lists that's a deposit on behalf of multiple clients, and we can't tell who the clients are because you can't read it, and the lawyer can't go back and he doesn't know who he deposited the funds on because he has multiple Andersons. So you can do a deposit, you can have one deposit slip for multiple clients, but you have to clearly annotate it both so that you can go back and tell who you deposit the client's identity. And also then if you're doing that, that multiple deposit, that also can create problems if you don't clearly remember how much was deposited for each client. Substitute checks deposits are permitted pursuant to the 21st Century Act. However, a lawyer must request and retain an image statement from the bank for each deposit. So what I'm talking about is you're doing mobile deposits. You know, you can do those, but you need to have that that image statement from the bank. And usually that's usually just an electronic copy of a paper check showing the back and the front side of it. And it usually has a statement saying that this is a official copy of the deposit. So you can do ATM deposits into the trust account, but you have to retain the deposit receipt and you have to identify the client on whose behalf the funds were deposited. You see that a lot too. A lawyer goes and makes a ATM deposit, gets the receipt, and then doesn't write on the receipt, doesn't keep the receipt, or doesn't write on the receipt the client's identity. Another thing that we see frequently are cash payments. So a client comes in and they pay you with cash. You have to have a receipt that is countersigned by the client, or if it's a third-party payer, and it has to clearly identify the client on behalf on whose behalf the payment was made. So we see various variations of this that are insufficient. It's not okay for you, lawyer, to just write a receipt and say, thank you, you paid me. I acknowledge you paid me a $5,000 retainer and give it back to the client, because the client has to countersign it. It's also not okay to send a client a text message saying, I acknowledge receipt of your $5,000 payment, because again, it's not countersigned by the client. So those are usually admonition level violations, but we do see them with frequency in our office. So let's talk about withdrawals. How do most lawyers withdraw funds from a trust account? Well, they do that through the use of checks, but you can also make electronic, telephone, or wire transfer withdrawals, but these require a memo that the lawyer has to create on your own. So the memo has to, you have to just create it. It doesn't have to be anything fancy. It can just identify who is authorizing the transaction. If you're in a firm with multiple people, it really needs to be the lawyer who's requesting the withdrawal from the trust account on behalf of the client to be signing it, because they're the one authorizing the disbursement. The memo has to identify the client, the amount, and the date of the transfer. And that's a record that you keep with your trust account records for 6 years. Did that answer your question from earlier?
Some of it.
Some of it, okay.
Is there more that?
Yeah.
Well, I guess I'm thinking about my software that I use for my client, you know, my client record, my client, the law firm software, which has a lot of this similar functionality. It has a function to show when the trust payment comes in, that it's been put in the trust, and when it's been, and when it's been earned, I can move it to the operating account and disperse it. So all of that is tracked within the context of the software. I can go in and see it, and so that is one, and I can run reports on it, and then I can print a report, for example. So that's one type of record keeping that it can show. It can show the withdrawals, it can show the disbursements, it can show when the trust money came in, it can show the client money when it came in, it's dated. Everything that we've sort of been talking about is like documented in the software, for example. What type of record is that? Like if I can run a report on those transactions.
We'll talk about that. But I have a question for you. How do you make your deposits into your trust account?
Well, typically they're made based on credit card payments. And so I have a third-party processor that handles it on LawPay, which handles attorney types of trust account payments from credit card vendors, and so that's the transaction, and it comes into my account that way.
Does it generate a receipt of some kind or a independent record?
It comes in a couple ways. It comes into my bank account, and so then I get a notification from my bank account that the deposit has been made, and I also get the update in my law firm software that's been made.
Well, the
Can
notification.
everyone in the back hear this? So we're talking about client software, primarily deposits being made into the trust account. Now we're talking about deposits being made via credit card, and this attorney is using LawPay. We are going to talk about LawPay later. LawPay is a service provider that is useful for getting credit card funds into the trust account. I just want to make sure people in the back can hear this.
Would you guys agree, though, that the receipt or the email or the whatever documentation you receive from your bank upon the crediting of that credit card payment can serve as replacement
Of a deposit.
of a deposit slip?
Right, and what I was talking about at the end, what the memorandum that I was talking about lawyers creating is a memorandum authorizing wire or electronic or telephone transfer withdrawals. And the reason why we want the signature on there is because we want the signature of the attorney who's responsible for the disbursement.
So even though it might be occurring electronically, there's like a separate memo that the
Yep.
attorney should be creating.
Yep,
That
creating,
contains
yep,
all those elements.
right.
Okay.
And again, this is for electronic, telephone, or wire transfer withdrawals. The lawyer who is authorizing the transaction needs to create that memo and sign it. And that's just that there was that's because we want to trace who authorized that and that it is actually an authorized disbursement. So what you were talking about was deposit. The memo is created for the transfer withdrawals that occur in forms other than by check.
But also talking about a withdrawal as it comes out of the trust and goes into the operating account, right? So that's not just a deposit, it's also a withdrawal.
Yeah.
Okay.
Any other questions?
We retain our books and records electronically. For the backup, we use an external hard drive, but is it acceptable to use Dropbox for the backup? You know, the security for Dropbox. I mean, I guess I'm old enough that I always think about that. What's really secure?
You know, we don't have specific requirements for, lawyers have to take reasonable steps to protect client confidentiality. Anytime you're using like a cloud service for the backup, there's always going to be a security concern. I don't think that we haven't gotten that specific with our opining on that issue.
So Cassie talked about records, trust account records. Now we're going to talk about what constitutes trust account books. Unlike records, books are the materials that a lawyer, him or herself, maintains internally to track the activity in the trust account. And those books include the items that are listed here: the checkbook register, client subsidiary ledgers, the monthly trial balance and reconciliation reports, and optionally, the receipts and disbursements journal. It used to be the case that in addition to the checkbook register, client subsidiary ledger, trial balance and reconciliation reports, lawyers were also required to maintain these receipts and disbursements journals, which were separate journals, one that tracked all the receipts or deposits into the trust account, the other that tracked all the disbursements out of the trust account, and then you total them at the end of the month and match them up with your check register and so forth. Those journals are no longer required, although some lawyers choose to continue maintaining them just as a separate check to make sure everything's okay with the account. And in addition to the books that are listed here, remember too what Cassie just talked about with respect to electronic or telephonic withdrawals from a trust account. You need to create that memorandum, create and sign that memorandum authorizing those transfers. All of the requirements that we're going to talk about with regard to trust account books are found in Appendix A to the Minnesota Rules of Professional Conduct. Let's first start and talk about a check register, which you see a sample of one here on the screen. A trust account check register, and if you look at Appendix 1, it is going to set forth these specific requirements that I'm about to relate. The checkbook register has to indicate, it's got to be in chronological order, has to indicate the date of the transaction, the date, let's talk about deposits first. The date of the deposit, the amount of the deposit, something that identifies the client on whose behalf the deposit was made, be it the client's name, initials, file number, whatever, but some client identifier. The amount of the deposit and a brief description as to the purpose of the deposit. For example, it's a filing fee advance, settlement proceeds, whatever. So date, with respect to deposits, date, client, amount, purpose, and there always has to be that running daily balance on your check register. So that's another requirement. With respect to checks that are issued on the trust account, and again, this check register is encompassing all of the activity in the account without regard to who the client is. It's all the activity that's occurring in the trust account. With respect to checks, much the same information has to be included. Date, the payee on the check, the client on whose behalf the check or disbursement was issued, the amount, the purpose, and then that running balance has to be there as well. So we talked about the check register, which includes all of the activity in the trust account. Now there's a separate book that has to be maintained that isolates individual client activity, and those are called client subsidiary ledgers, and you see a sample of one here on the screen. So a lawyer is required to maintain a separate client subsidiary ledger for every client on whose behalf the lawyer deposits funds into the trust account. And that subsidiary ledger is going to track all the trust account activity for that individual specific client. Again, if you look at Appendix 1, it's going to give you some very specific information that has to be included on a client subsidiary ledger, much of the same information that has to be included on a check register. The date of the transaction, the payee with respect to any checks, purpose of the transaction, check number, amount, and again, also has to have that running balance. And a running balance in a client subsidiary ledger is important for two reasons. One, if that balance ever goes negative, that's going to be indicative of a serious, potentially serious problem, and it needs to be corrected. So you need to keep that running balance going. But also when you get to the end of the month and you go through the trial balance reconciliation process we're about to talk about, you need to have that month-end balance clearly reflected on the client subsidiary ledgers.
How common is this when failure to keep client subsidiary ledgers? How frequently do we see that over OLPR?
I'm glad you asked me that question, Cassie. As you see when we get down the road, and we're going to talk about some of the most frequent problems with regard to lawyer trust account maintenance. Failing to maintain these client subsidiary ledgers and then failing to perform the required trial balance, which we'll talk about in a second, are the two most common errors lawyers make with respect to their trust account books. And yet they're the two most important parts of the required trust account books, but we'll talk about that.
Can I reconcile my books and records if I'm not keeping client subsidiary ledgers?
You cannot reconcile a trust account in the manner required by Appendix 1 if you're not keeping client subsidiary ledgers. You just can't. And you'll see why here in a second. So we kind of alluded to this, client subsidiary ledger balance cannot be negative. What's happened when one client's subsidiary ledger, the balance in a client subsidiary ledger has gone negative? What does that mean?
You use someone else's money.
Correct. You may have used somebody else's money, and that is misappropriation, and that is a serious offense. So that's another reason for keeping that running balance on your client subsidiary ledgers. Watch out for the negatives. If you see one, figure out why it's there and fix it as quickly as you can. Obviously, at the conclusion of the representation, the client subsidiary ledger balance should be zero. You're no longer representing them. Any money that you had in the trust account on their behalf should have all been dispersed. In addition to ledgers for clients who have money in the trust account, lawyers sometimes have to maintain two additional ledgers. One is a ledger tracking interest, and that's only necessary where you have a bank that pays the interest into the account in 1 month, then remits it to the IOLTA program in another month. Well, you've got that carryover interest balance. You need to keep track of that and include it on the trial balance report that we'll talk about in a minute. So in that scenario, lawyer needs to maintain an interest ledger. If it's a situation, which is the more common, where the interest is going into the account in 1 month, being remitted from the account the same month, you don't have to worry about an interest ledger because it's just a wash. The second other ledger is a ledger that tracks any funds that the lawyer has in the trust account as a cushion against bank charges and the like. You need to have a ledger tracking those funds as well. And note that Appendix 1 says that lawyer's balance cannot exceed $200. So it's got to be a nominal balance. As Cassie mentioned earlier, every trust account, whether it's a pooled trust account or an individual trust account, has to be interest bearing.
So it's all in here.
That part's clear. And as I said, most banks do the payment into the account and remittance from the account in the same month. It's only some outstate banks that handle it differently.
And you can ask your financial, when you're thinking about opening an IOLTA account, you can ask the bank that. When do you remit interest payments? You just find out. If they don't do it monthly, and then go to a different bank. You don't have to deal with the interest ledger.
Here's just a quick example. We won't spend much time on this, on what a ledger that's maintained to track interest might look like. You see the date, purpose, the amount, and the running balance. And if you were to maintain a ledger for, the funds that the lawyer has in the account to offset bank charges, it would look very much the same, except that the title would obviously be different. Now we're going to talk about trial balances and reconciliations. Again, one of the parts of the reconciliation process that is most often not properly done by lawyers, and if it's not being properly done, it can create tons of problems for you. What you're looking at on the screen is not actually a trial balance or a reconciliation, it's a checkbook register. We're going to start with the trial balance reconciliation process using the check register. Let's define what a trial balance and reconciliation is with respect to the trust account. A trial balance report is done at the time you are reconciling your monthly trust account bank statement. And it is a listing and a totaling of all the balances reflected by your client's subsidiary ledgers as of the date of that bank statement. So what you're calculating on a trial balance report is here's how much client money I'm supposed to have in my trust account. These are my total client balances and interest and surplus funds as well. When you reconcile the trust account,
CV.
You look at your checkbook balance.
CV
You look
1579.
at your trial balance, and then you look at your bank statement balance, which may have to be adjusted. And all three of those balances have to be precisely the same.
January 17th.
Let's say the bank statement balance is less than the trial balance total. What does that tell you?
I'm guessing it was the April 20th, but
It could be that. To simplify, you simply don't have enough money in the trust account to cover the client obligations, and that's a problem. So that's the purpose of the exercise, to make sure that the actual balance in the account is appropriate given the amount of money you're supposed to be holding for clients. So we'll start the trial balance reconciliation process by looking at this check register. When you're drawing the check register balance for purposes of the reconciliation process, obviously look opposite the last entry on the checkbook register for the month in which you're reconciling. In this case, the balance is $3,471. That would be the check register balance that you would work with. Here's a trial balance. As I said, it's simply a listing and a totaling of the client balances, and in this case, there's some earned money too and some interest that's supposed to be in the trust account. So on January 31 of 2019, this lawyer is supposed to have in her trust account $3,490.19. That's what that tells us. Here's the reconciliation. Let's just assume for purposes of this example that the bank statement, or the check register balance was also $3,490.19. That's here. Here's our subsidiary ledger trial balance, which we just calculated, but the bank balance is $5,905.19. The reason for that is because there are a couple of checks that were issued and posted to the client subsidiary ledger and the check register, but didn't actually clear the account in that month. And so those have to be accounted for, backed out of the bank statement balance. And you see when that's done, that bank statement balance then also equals $3,490.19, which is exactly what you want it to be. If those three balances don't reconcile, you have to figure out why and correct whatever issues are causing it not to reconcile.
What are some of the usual culprits for why those aren't?
Somebody mentioned failing to post a check, either on the subsidiary ledger or on the check register. Maybe there's another outstanding check that you're not picking up as part of the bank statement reconciliation process. Maybe there's a typo on one of your ledgers, so that the balance you're coming up with is goofed up.
I found that voiding a check will make that number off if you don't run your reports in time.
Oh yeah? With which program?
QuickBooks.
Oh,
And QuickBooks, if you void a check in that year and you didn't run your reconciliation report, your reports won't match. It will be off that voided check.
all right. I'll have to look at that. I didn't know
Yeah,
that.
I ran a report after I did the reconciliation. I ran it like a couple weeks later, and it was off by that voided check.
So the reconciliation didn't pick up the fact that check was voided.
Correct. In the system, in QuickBooks system.
And then did that perpetuate then for the next several months?
No, it was cleared after the next month.
Okay. Depositing funds, we're running short on time, so I'm going to move through this last one pretty quickly. Huh? Yeah. Long on time? Yeah. Oh, we're running long on time. I get to talk more. Okay. So when you deposit, there really are no restrictions on how to deposit funds into a trust account. You can do it electronically, you can do it at an ATM, you can do it in cash, you can do it by way of a deposit slip, walk to the bank, mail it, whatever. So there's really no restrictions on that. When you are depositing a check, let's say it's a settlement check, and you, the lawyer, have entitlement to some portion of those settlement proceeds. Even though that's the case, you still are required to deposit the entirety of that settlement check into your trust account intact, and then make the disbursements to yourself, to your client, medical providers, whomever, from the trust account. But the deposit instrument itself, the settlement check itself, has to be deposited in its entirety into the trust account. You need to promptly notify your client when you have received funds on that client's behalf and are depositing those funds into the trust account. And that's required by Rule 1.15C1. Also, if you have a contingent fee arrangement with your client and you've now received the settlement or settlement proceeds or some recovery, you need to create a settlement statement that shows the amount of the settlement and how it is that the client's share of that settlement is being calculated. And that needs to be provided to the client. So the client is clear on how it is that the client is getting, what amount he or she is getting from that settlement.
All right, so now we're going to move into talking about how you can handle credit card fee payments. How many of you are using credit cards to accept payments? Just a couple here in our live audience. You are allowed to use credit cards to accept payments. Appendix 1, Part 1, Paragraph 10 allows you to do that, so it is authorized by the rules, but you do have to be cautious in the way in which you use credit cards. So one of the concerns we have about credit cards is you have to be cautious because we can't allow any third party to have access to the trust account itself, Because if a third party has access, then you're jeopardizing the fiduciary nature of the trust account, that fiduciary nature of the funds that you're protecting. So we can't be having credit card issuers have access to that trust account. So using services like LawPay, is anyone else here using LawPay? We just have one person who's using LawPay. A service like LawPay is completely appropriate for handling credit card payments into your trust account. One way to handle credit card payments is if it's for earned fees, those credit card payments should be handled exclusively through the business account. Those should never be going into your trust account because why? It's your money. It's already earned. So if it's already earned, you should never be putting that in your trust account. That would be commingling. If it's an advance fee and you're not using a service like LawPay, then how you should be handling that is taking the payment in through your business or operating account and then transferring that money to your trust account. So if you're not using a service that make sure that a third party does not have access to your trust account, then take that payment in through your business account and immediately transfer it over to your trust account. And then of course, once you earn the fees, transfer those back over to your trust account. If you are using credit cards and you have the bright idea that you should transfer fees incurred from the use of credit cards onto your client, think twice about that. We really encourage you not to do that. And if you are going to think about doing that, you need to comply with the Minnesota Consumer Protection Act. The statute is 325G. 0.051, and there are very specific requirements as it relates to the Minnesota Consumer Protection Act. It even includes having a posting within your office advising that you are going to be imposing fees, and the fees can never exceed 5% of the purchase price. So people need to be very, very cautious when they're passing fees associated with credit card usage onto their clients. You also need to make sure that you're holding any cost advances from credit card payments. You're putting those into your trust.
And that can get complicated too, where you're processing one credit card transaction for a retainer and costs. So if the client's paying you like a $5,000 retainer and then $500 in cost, and you run that as one credit card transaction, you might have a fee agreement, like I cited you earlier to Rule 1.5B1, where you can not have to put that advance fee payment into your trust account. So that properly stays in your business account. But we see lawyers who then forget to transfer over the cost payment that the client made. And cost advances are always funds that need to be held in the trust account.
And cost advances, those are things like expert fees, filing fees. Don't be leaving those things sitting in your business account. They do need to move over to the trust account. We're now going to talk about disbursements from the trust account. I'm looking over at my partner here because I'm not near the computer, so I just need to make sure the screen is advanced. You do need to make sure when you're dispersing from your trust account that the check is available. What does it mean, not available? That funds are available is not enough. You have to make sure that that the check has cleared. Usually local checks, that's 3 days. International checks, it can be much longer than that. So this requires actually communicating with your bank to make sure that the funds that you're processing and that you are going to be accessing, the funds have actually cleared. It is not a good idea to make same-day disbursements from the trust account. There are certain occasions when that is okay. We had a little discussion about this from the office before we came here today. One of those exceptions can be cash deposits and then making a disbursement by check. I come from a criminal background, and I'm like, what if that? What if that?
A prosecutor, not a criminal.
Yeah.
So to be clear.
So I'm like, what if that cash payment was counterfeit funds? It could be quite possible that someone paid a retainer and the cash was counterfeit funds, and the bank then reversed that deposit. Is that really available and clear? So that could be an issue. So just make sure you're doing your client confidence if you're taking in those cash payments. In a real estate closing, you can also disperse on the same day, and that means the whole cash payment. It's not just in the criminal context. It could be in a whole bunch of contexts that could happen. But in real estate transactions, wire deposits and certified checks can also be dispersed on the same day. That's also grounded in Rule Appendix 1, Paragraph 1, Paren 11. You need to make sure that if you are dispersing on the same day in these situations, that you do it before the end of business day cutoff. So usually like 3 o'clock. Don't be running right up to the wire on that.
Okay. I just want to make the difference between fund availability and check clearing clear. When you take a deposit to your bank, within whatever your bank's policies are, a day or so, your bank is going to say to you, the funds are available. That means that your bank has placed those funds in your account and they made them available to you. But what has to happen before those funds truly are available is that check has to go back to the bank that issued it. And it has to clear on the bank on which it was issued. Your bank can't know that yet. And so you have to wait, as I said, until that bank check makes it all the way back to the issuing bank, and that bank clears those funds for disbursement.
Okay. And the float on that, the float between funds available and clearing the issuing bank are what trust account scammers use to target lawyers. And we'll talk about that at the very end. But understanding that float period and looking at your bank and saying funds available means I can issue this check can get you into a whole host of troubles when you're dealing with a client that is actually a trust account scammer.
Some other issues that can occur when you're dispersing from your trust account is we hear people saying, can you post date a check? No, just flat out no, you can't do that. There's also a question about when you can or should remove earned fees or an advance fee or a flat fee agreement from the trust account. This all really it does really tie back to Rule 1.5 as well. You need to read Rule 1.5. If you are engaging in any flat fee practice, you need to read Rule 1.5 and make sure you're compliant with it, and you need to have a written fee agreement. If you are placing fees in trust and you are not engaging in that practice where you're just putting everything into a business account, so let's say that you are putting all of your fees into trust and you're removing them as earned, you need to remove them when they're earned. I was presenting at another CLE and someone is like, well, you know, I just do my books whenever, and then things get kind of messed up and I'm not doing it monthly, so they just kind of sit in there. But that's not okay. That's commingling. When you earn your fees, they're earned, and you need to take them out of the trust account and move them to your operating account. That's what you need to do. You can't leave them in there. Settlement funds, they are not available to you until they clear the Federal Reserve System, and you need to communicate this with your client. This is where we have a tie-in with other rules of professional conduct as well. This is tied in with Rule 1.4. So it's important that you communicate this with your client, and in these situations, these are clients that can get a little upset. They're waiting for this money. They may not be happy about what the contingency fee agreement ultimately looks like in the end, but you need to let them know that although you have received this settlement and the check is going to be coming, that it is not available until the funds clear the Federal Reserve System. So again, that's complying with Rule 1.15, and it's complying with Rule 1.4 in the way in which you communicate with your client. Cost advanced and cost reimbursed. Costs that are advanced, so the client is advancing you costs. The client with your retainer is giving you money and also paying for your retainer and costs that they are giving you in advance. Those funds need to go into the trust account. Now, what about other situations where you have advanced costs to the client? You have paid costs on behalf of the client. If you use your own funds and now the client has reimbursed you, how do you handle that? Where does that money go when the client reimbursed you after you have already paid it? No. It goes into your operating. Because you've already paid it, you've already incurred the expense, so you're going to put it into your business account or operating account. That's where that's going to go. Any questions on that disbursement section?
Just real quick to sum up, how can fees be removed from a trust account? Most fees are removed by the lawyer issuing a check made payable either to himself or to the law firm or to a third party in settlement of some obligation owed by the client. As previously stated, each check needs to be clearly annotated with the identity of the client. We've also talked about electronic wire and telephone transfers. Lawyers can make withdrawals from the trust account by bank wire, electronic or telephone transfers. Just for clarification, a wire is a transfer from your bank to another bank. An electronic transfer is between accounts at the same bank. So a lawyer dispersing funds electronically from the trust account to the law firm's operating account, which is maintained with the same financial institute. For those withdrawals, you have to have that memorandum that we talked about earlier, signed by the authorizing lawyer, and also with the date, client identity, and the amount of the disbursement. You can't take cash from your trust account. You can't write out a check payable to cash and present it at the bank and get cash from your trust account. You also can't have a debit card tied to your trust account. Just a couple of random issues. Uncashed checks. So we get this on the advisory opinion. I issued a check to my client. It's been more than 90 days. What do I do? After 90 days, most banks will consider a check stale and they won't consider such a check. So the only way to ensure that, so after 90 days, your client probably can't cash your check. So what do you do there? Lawyers don't want to then issue the client a second check, because then what if the client goes and tries to cash both checks? I mean, I suppose some banks don't always adhere to this 90-day rule and would cash it. So you have to go and ask your bank to issue a stop payment order. That's really the only way to deal with that. And it just happens. People lose checks for various reasons, and sometimes you can't find the client and mail gets returned. But if it's after 90 days, that bank is probably not going to honor it, and you should do a stop payment on it if you're going to be issuing a second check. This is another frequent advisory opinion call that we get: abandoned client funds. My client got a settlement. A lot of people, especially when they deal with low income clients or pro bono clients, those clients are in transit, meaning they don't necessarily have a home. So they're moving between places and lawyers aren't able to locate them, or for some reason a client disappears. This does actually happen a lot. What are your options as a lawyer? Because you have to keep tracking that money in the account. Do you have to track it indefinitely? No, there is something called the abandoned property statute. That's Minnesota statute 34532. And that permits a lawyer to transfer abandoned client funds to the Commissioner of Commerce if the lawyer has held the funds for at least 3 years. The funds should be transferred to the Commissioner in the form of a check written on the lawyer's trust account, along with a report of the client's name and last known address. You keep a copy of that report in your client file. If you call me on the advisory opinion hotline and you say it's been over 3 years, I'm still going to counsel you that you have the obligation to make a good faith effort to locate that client. You need to get on Google. You need to contact the post office to see if there was a last known forwarding address. But the reality is many lawyers deal with clients who are transitional, homeless, or move around a lot, and sometimes lawyers aren't always able to find clients. But you have to wait for that 3-year period to run. You can't do it unless you've had the funds for 3 years.
And we actually do get a lot of calls about this, and on the advisory opinion line, I usually tell people you really need to demonstrate that you have tried to find people. If you have access to Clear, any investigative services, some lawyers are hiring other lawyers or investigative firms to try and track the people down. You really need to document that. And the Commissioner of Commerce now, everything is online. There's no paper forms now. You have to submit all of your documentation to them online. So make sure you check that out on the web. But really document your investigative efforts to try and get that property back.
Just a question for Kat. Would you clarify, if funds are paid after earned,
they should not be deposited into the trust account. If that is the case, then is it acceptable to show just on client ledger?
Did everybody hear the question?
So
The question what? Go ahead.
the question was, is it correct that if the funds have already been earned, they should not be deposited in trust? And then what records should those be recorded on? Should they just be recorded on the client ledger?
Well, if it's money going into the business account, there is no client ledger. But Appendix 1 does include some requirements for business account records, including a fully annotated check register. So the funds would go into the business account, and then there'd be an entry into the business account check register consistent with the requirements of Appendix 1, which are very similar to what is required for a trust account check register. Does that make sense?
I had a question about tracking down missing clients. If you cannot find a client and it's getting to the point where the cost of tracking down the client exceeds the value of the actual settlement that you're trying to pay the client, is there ever a point where the good faith efforts will be considered exhausted when the cost actually exceeds your ability, the amount of the settlement you're trying to pay the client? I'm not sure if that's very clear. I'm a brand new lawyer. I don't have a lot of experience with this. So
Yeah,
Can you
some of it,
summarize the question for us?
yeah, I understood it. So,
But you have to repeat it.
yes, I'm going to. So basically, what if the cost of tracking down the client exceed the amount of the settlement funds that you're actually holding in the trust account? We don't have there's no strict requirements for tracking down the client. What I advise people on the hotline is if you have Westlaw, there's a people search function on Westlaw. That's part of your Westlaw package. If you do a Google search, do a reverse address search on white pages, you can contact the post office to see if they've left a forwarding address. You can do other things. It's reasonable. We're not going to ask that you go hire a company to try to a private investigator to go track down someone to return a $100 retainer. That's not what we're talking about.
So the director's office operates a trust account overdraft notification program. In order for a bank, a Minnesota bank, to be approved to maintain lawyer trust accounts, it has to agree, I think we mentioned this earlier, it has to agree to two things. One, it has to agree that it will report overdrafts on lawyer trust accounts to our office. And two, it has to agree to pay a certain minimum level of interest on the lawyer trust accounts. So those banks, those approved banks, are then supposed to report to our office an overdraft on a lawyer trust account at or about the same time that the account holder, is getting notice of that same overdraft. When we receive the overdraft, we then send a letter to the account holder, and that letter primarily requests a written explanation for the cause of the overdraft, a copy of the instrument, check or other instrument that caused the overdraft, and then we routinely request the lawyer to produce 3 months of their complete trust account books and records. And we do that for two reasons. One, to confirm the explanation that the lawyer is providing for how the overdraft occurred, but two, and just as importantly, to educate the lawyer. If there are issues, minor issues in the lawyer's trust account books and records that we identify, we want to be able to help the lawyer correct those errors, correct those deficiencies as part of the overdraft program. The letter that we send out upon receipt of an overdraft tells the overdrafter that if the overdraft was solely the result of a bank error, then the lawyer need not provide this 3 months worth of books and records, but will need a letter from the bank in which the bank takes responsibility for the error. We're pretty strict on what is and isn't a bank error. Like, I had someone recently who used a business account deposit slip, but took a pen and scratched out the account number and hand wrote the number for the trust account. Wanted to make this deposit into the trust account. Well, guess what? The reader that reads your deposit slips is going to pick up the handwriting. It's going to pick up what's printed on the deposit slip. So that deposit, instead of going into the trust account, went into the business account and an overdraft resulted. That's not bank error.
Linda, how about not understanding your the difference between funds available and funds cleared? So you deposit a settlement check, your client pressured you to get the funds to him immediately, you issue a check to the client the next day, he goes and cashes it, and you find out that the opposing party gave you a check that was insufficient funds, so it creates an overdraft in your trust account. Is that bank error?
No.
Well, my bank told me that the funds were available.
Lawyers are responsible for knowing their bank's deposit hold policies. You have to know that. So when you deposit a check in your trust account, you have to know how long it will be before those funds are available to you. And that's on the lawyer, not on the bank. A bank error is something like this. A legitimate bank error is something like this. For whatever reason, a bank employee took a check that was issued on some totally unrelated account and posted it to your trust account. That's a bank error. When the bank itself makes errors like that, and those result in overdrafts. So I told you we send out this letter to the account holder where we receive an overdraft notice. If the response comes back and it's a legitimate explanation, it's a legitimate mistake, that one-time mistake that the lawyer made that resulted in the overdraft, and the books and records look pretty good, that's the end of it. We just terminate the inquiry, nothing more happens. If we get records, the books and records from the lawyer, and there are these, some minor deficiencies that need correcting, we will help the lawyer to correct those deficiencies, probably ask for a corrected set of books and records, but then again, terminate the inquiry at that point. Where our review of the books and records we receive in response to an overdraft indicates chronic or serious problems, shortages, commingling, whatever the case may be, then we will convert that informal overdraft inquiry into a formal disciplinary investigation and further investigate the lawyer's trust account practices. That often involves a full-blown audit of the lawyer's trust account. Here's a list of some of the top bookkeeping errors that lawyers make with respect to their trust accounts, and we talked about this first one quite a bit. That is the most common error, the failure to maintain subsidiary ledgers and or the monthly trial balance and reconciliation reports. As I said, if you're not maintaining client subsidiary ledgers, there's no possible way for you to reconcile the account in the manner required by Appendix 1. Sometimes the deposit slip is insufficiently detailed, and so that the right information doesn't get into the client subsidiary ledger, the check register, and that can throw things off. It's crucial to have a computer backup system. Cassie and I have a case right now where the lawyer received client funds back in, 2012 or something, and for whatever reason said he was still holding those client funds. So we asked for records back to 2012 to confirm the fact that that money remained in his trust account. Well, he didn't back up, and then he had a computer crash, and darn it, I just can't provide those records because he didn't adequately back up. And so that's a critical step in the required process. Failure to track and account for uncleared checks and deposits. Remember, that's part of the bank statement reconciliation. You need to be clear about that. Again, failure to appropriately handle or account for interest disbursements. Remember, if you've got a carryover interest balance, you need to have a ledger, and the balance on that ledger needs to be part of the trial balance total. We've discussed this too. There needs to be a lawyer, at least one lawyer that signs every. Did we talk about that? Yeah. Did we? Yeah. No, I didn't miss that. A non-lawyer can be a signatory on a trust account check, but that non-lawyer cannot be the sole signatory on a trust account check. Every trust account check has to bear the signature of at least one licensed lawyer. So if in your office you have a process where you have two people signing trust account checks just as a check, one of those people has to be a lawyer. Every trust account check needs to be signed by a licensed lawyer. Failure to track and cover check printing charges, we see that throwing things off for lawyers. And, you know, it's, in many cases, it's advisable to use accounting software, QuickBooks, Quicken, other programs are available. It just, especially if you've got a high volume trust account, you could post things once and it goes everywhere it's supposed to do, everywhere it's supposed to go. Whereas if you're doing it manually, you got to make the deposit, annotate the deposit slip, then you got to make an entry to your ledger, then you have to make an entry to your check register. Using the computer software really simplifies things. And both these programs, QuickBooks and Quicken, can be manipulated to create all the trust account books that are required by Appendix 1.
So we're running a little bit short on time, so we want to get to the discipline section real quick.
Oh, I'm going to do that. Okay. So understand that lawyers have been disciplined by the Minnesota Supreme Court for the mere failure to maintain required trust account books and records. And that's shown in the In re Porter case. The site is on the board here. It also occurred in the LaChapelle case, although there were other issues there. But in the LaChapelle case, Mr. LaChapelle claimed that he had delegated responsibility for his trust account bookkeeping to his office manager. His office manager assured him that everything was going great, and based on that assurance, he signed his lawyer registration statement certifying that everything was going great. Turns out it wasn't going great. And Mr. LaChapelle argued to the court that it's really not entirely my fault because I deferred to my office manager. And the court said, no, it's ultimately your responsibility, Mr. LaChapelle, to ensure that your delegate is properly maintaining your trust account books and records. And at a bare minimum, the lawyer should, at the end of each month, the lawyer should look at the bank statement, the trial balance report, and the reconciliation report and make sure everything balances as it should. That's the bare minimum level of review that lawyers should be undertaking when they delegate a day-to-day responsibility for the trust account. That's all I have.
And again, just like we talked about earlier, if you're failing to keep all of the trust account books and records, it can still be disciplined. You have to keep all of them. So the court said just failure to keep a subsidiary ledger or to do a trial balance report is still a failure to keep trust account books and records and can subject you to discipline.
So at this point in the talk, you're either probably like, wow, I'm really glad I don't handle client funds, so I don't have to worry about any of this. Or you're like, this is so basic, I have all of this down and I'm not doing anything wrong. Or you're like, holy cats. I'm really worried and I have to immediately go back to the office and check on some things. We want you to feel okay. You know, we are going to talk to you about some discipline cases, but none of us sit here going back to our office or sitting up here being like, I can't wait to file a petition. None of us feel that way. That's why we do these educational pieces. We want to educate lawyers. We want to make sure that the bar is at a good place. That's why we have the advisory opinion service. Call us, talk to us. We want to help you avoid misconduct. So even though we're talking about this, this is not a scare tactic. This is to try and help educate you. And really that's what it's about, to kind of help you understand where things can fall and to help you avoid things. One trend we're seeing is partners who are delegating, or just joint lawyers in a firm who are delegating their bookkeeping responsibility, and it's just going completely sideways. And we want you to know that both people in those situations are going to be disciplined. There have been a series of cases this year where this is happening. Knepp and Hackert have been two. Carlson and Van Bruggen are another pair. Those have been public reprimands where lawyers in those cases have just completely delegated their books and records responsibilities, didn't pay any attention to what was happening, and things went awry with both the trust and business accounts. And those lawyers were publicly reprimanded for their failure to supervise and take account of what was happening with the books and records. So really, pay attention to this. Even if you send your books and records off to an accountant and you're like, I got this, I sent it off to an accountant. They know how to handle books and records, right? They're good with finances. They don't. Accountants don't understand the legal requirements of the Minnesota Rules of Professional Conduct. So just don't think that you have a carte blanche because you have an accountant taking care of your books and records. You as the lawyer have a duty to make sure that you explain and supervise your bookkeeping responsibilities to the person you have delegated it to. Please just make sure that you're taking care of that. Commingling is also a significant issue, and it can happen a number of ways. And it results in public discipline, and it can result in significant public discipline. One way is by having your personal funds in the trust account. The second way is by failing to remove earned fees from the trust account. The third is by having a significant cushion that exceeds more than $200 in the trust account. You learned earlier that you're allowed to have $200 in there to account for things that can happen. Some lawyers are like, hey, I'm bad at math, so I want to have more of a cushion. You can't do that, all right? You can't have more of a cushion than $200. By doing that, it's going to constitute commingling, and you could be subject to public discipline. You also can have commingling when you end up with this issue that Cassie talked about, where there's a single check for a cost advance and earned fees or a flat fee, and you fail to take the earned fees out and you just leave it all in the trust account. And again, we're seeing public discipline resulting in these cases. And again, I'm blowing through this a little fast.
Well, Jennifer, why do lawyers commingle personal funds in their trust account?
Why do they do that?
Why do they do that? Why have we seen that in discipline cases?
Why do lawyers not take their own money out of the trust account? I don't know why lawyers do that.
Are they sometimes hiding assets from the IRS?
Well, they are doing that. So we do. so people are using their trust account inappropriately. Of course, I don't want to think that lawyers would be doing that, but they are. And that's also why we don't want to see commingling happen, because when you are doing that and your personal funds are there, then what you're doing is you're subjecting your client's funds, you're taking away that fiduciary nature of the account that we talked about earlier, and it's then becoming subject to attachments by those third parties that you're supposed to be protecting it from. So then the IRS comes in, they're trying to grab those funds that are yours, and they could get at your client's funds. And that's exactly what we're trying to make sure doesn't happen, and you have now allowed it to happen. That's very, very bad. What is misappropriation? Misappropriation is when the funds belonging to your client are not deposited into the trust account and are used for any purpose that is not specified by the client. Now, misappropriation can just be straight up stealing from the client too. So you could put the client funds in the trust account and then you just steal them. So that's misappropriation too. But other things that constitute misappropriation are things like taking a filing fee from a client, putting it in your business account, and then you never file anything. That's misappropriation as well. People don't always think about that, but that's misappropriation as well. If you want to say that you are borrowing client funds, that's not going to cut it either. You don't get to borrow client funds. That's misappropriation as well. What are some other ways that misappropriation can occur? Issuing checks from your trust account that exceed the trust account balance. So that's some of the examples we talked about, getting to that negative trust account balance when you're not doing your reconciliations. When you're failing to transfer your credit card payments over to the trust account, that can be misappropriation. Paying non-client expenses out of your trust account. We're seeing this. So you're paying your office rent, you're paying your country club dues, you're paying your Lexus payment, maybe you're paying your child support obligations. Anything you're paying that does not relate to your client out of your trust account is misappropriation. The other thing that I think people sometimes miss the boat on that happens and none of you would do this because you're all here attending a CLE, but this we often see with people that tend to end up experiencing mental health or substance use issues is just complete client neglect. So they end up abandoning the client, they neglect the file, they don't do any work, but they have accepted a fee. That ends up being misappropriation. And you know, if you see, this is a side note and not related to a trust account, but anytime I get to talk about it, I'm going to, and my colleagues are going to get sick because we're running short on time. if you see a colleague going down that road where you just see someone spiraling down, grab them. Don't walk past your colleague. Just try and pull them aside. Wellness is a big issue right now. Get them in touch with someone because this is happening a lot in our profession, and make sure each other as well. So if you see those people who you can just see something isn't going right, they're not showing up at court, they're not filing their documents, try and grab onto them so that we don't have this happening to clients, we don't have this happening to each other, and make sure each other as well. What are some other variations on misappropriation? I'm going to have Cassie actually talk to you about the Escala case because it was hers.
The Escala case touches on a whole host of ways to do bad things with your trust account. So,
And your business account.
and your business account. So one of the things that this case highlights is negligent misappropriation. So when you're not keeping good books and records, and you don't know what funds you're holding on behalf of each client. So you aren't tracking what clients A and B have in the trust account. You think A has $1,000 in the trust account, but they really only have $200. So you write a check on behalf of client A to someone in the amount of $1,000, but they don't actually have that in the account. So the $800 that you're using comes from client B. And that is negligent misappropriation. Lawyers will sometimes run shortages because they aren't, because either their disbursements on behalf of clients, or even more harmful, the lawyer doesn't even know how much his own attorney's fees are. He doesn't know how much he's earned. He thinks he's earned this amount and he's dispersing funds and payment to himself, but he's not tracking how much the client actually has in the trust account. So by paying himself, he's taking money from other clients to do so. Also, yeah, was there anything else in that one? Yeah, there was a whole lot. I do want to get to our last slide though. Really quick, trust account scams all have some things in common, and this list right here is a red flag to you as a lawyer when you should be wary of a prospective client. Usually the prospective client solicitation comes in the form of an email. Oftentimes it involves a foreign client. The legal matter usually doesn't actually require you to do any legal services. You're essentially working as a collection agency. They want to hire you to collect on a spousal maintenance award from a client or from an opposing party, and the opposing party magically just agrees to provide you with a $500,000 check. The amounts are usually large. You're not actually doing any legal work. All the trust account scammer wants you to do is to accept this phony check, this phony wire transfer into your account, and then the client will have urgent circumstances that require you to disperse those funds to them within like 24 hours. Usually they'll want to try to do a wire transfer to a foreign institution because the float time's longer, and by the time you figured out that this is a fraudulent client and those funds have been dispersed, that original deposit is reversed and you're stuck with a huge shortage. You should know that lawyers have been disciplined for this. There's a really recent case, which is a great example. I don't have time to cover it, but it's in re Crabtree. If you'd like to review the facts on that, there's another one in re Olson. But both our office, depending on how much of your client funds were compromised by falling victim, and whether there were red flags that you as a lawyer that were obvious to a reasonable attorney that you missed. You might face discipline for being embroiled in the scam. Some of them are very sophisticated, and those aren't the ones where lawyers are facing discipline. It's the one where the lawyer there were things like even the email address that the client sent didn't match the name, and they were a client in Japan wanting you to then wire transfer a spousal maintenance award to a bank in Thailand. Like that, nothing is making sense here. I mean, you kind of have to sit down and wonder, why is this foreign client contacting you, Minnesota attorney? And that's really the Crabtree case, and it's a really interesting read. Also, on a closing note, we have an advisory opinion service. If you have questions about your trust account, you can call us at the number on the slide, and you may also reach us by email. We are happy to answer what we can. Thank you.
Any questions?
for the bookkeeping and record keeping requirements?
Yeah, if you grab the brochure out there that's called Other People's Money, there's samples in there.
This?
Yep.
For samples in here?
I mean, you can't use them directly, but they show you.
Are they, okay, I guess I didn't see them.
There are resources on the website too, under the link